This commission is expected to regard the Kpandai parliamentary seat as vacant, though it is a seat that was decisively won by the New Patriotic Party with a clear and convincing. But here is the profound constitutional and historical defect at the heart of this matter. As I stand before you, the Honourable Member for Kpandai, Matthew Nyindam, has duly exercised his constitutional rights. He has filed a stay of execution, halting to the Court of Appeal. And 3, he has initiated an appeal to the Supreme Court, rash proceeding, and arrogantly presumed to be preempt our superior courts before they have uttered a single word in this very house. Let us consult our own ledger. Our institutional history reveals a consistent bipartisan practice of protecting a member's mandate until the legal process is conclusively settled. We have never treated a contested first instance order as an immediate death warrant for parliamentary tenure. Let me cite specific examples. In the case of Samuel Nyemikan of Welensee, after the High Court was due, it continued to recognize him as a sitting MP throughout the entire appeal process. The seat was only declared vacant after the Court of Appeal delivered its final judgment. In the case of Eric Amwating of Nkranza South, detained abroad on serious charges, this House resisted calls to declare his seat vacant while his legal status was unresolved. Vacancy occurred only upon his own properly executed resignation. Trigger. When circumstances allowed, when he was granted a presidential pardon, he returned to this chamber on 10th of June 2008 and was permitted to sit and perform duties as MP. His tenure ended with the dissolution of Parliament. In the case of Adamu Dramani Sakandare of Boko Central, the Honourable Member continued to serve in Parliament for years while the courts determined civil challenges to his eligibility. It was upon his final criminal conviction and subsequent imprisonment in July 2012 that he became legally incapacitated from performing his duty as a member of Parliament. Even as he pursued an appeal, he was granted a presidential pardon in December 2012. In any case, a by-election could not have been constitutionally justified since his incarceration occurred less than 6 months before the 2012 general election. Let me address the case of James Jechi Kwesi, which is often mentioned. A clear look at what actually happened shows why rushing on Kpandai is wrong. Here are the facts. Kwesi was sworn in and served as MP in January 2021. Even though a court case was already pending, Parliament allowed him to work, just as we have done in other cases. In July 2021, a High Court nullified his election, but even then, Parliament did not immediately declare his seat vacant. The real change came from the Supreme commanding Kwesi to stop acting as an MP. And in May 2023, the Supreme Court gave its final judgment, ordering Parliament to remove his name. High Court ruling alone. It was based on specific final orders from the Supreme Court. Now compare this to Kpandai. Today, we have no order from the Supreme Court. We have no injunction, it's under appeal. To use the Kwesing case to justify instant action in Kpandai turns the truth upside down. Kwesing's case teaches us to wait for the Supreme Court's final word. In Kpandai, we are ignoring that lesson and acting before the first appeal has even been heard. We cannot use a case that required court intervention to justify acting when the Supreme Court has not spoken at all. The pattern, therefore, Mr. Speaker, is undeniable. This House has always required one of three conditions: the exhaustion of appeals, a final specific order from the Apex Court, the member's own resignation. Article 99, 1E of our Constitution is precise. A seat becomes vacant upon a determination by the appropriate judicial authority. Our history proves that a determination is not the first word of the High Court. Our history proves that a determination is not the first word of the High Court, but the final authoritative word after the appellate process is complete. Our legal system is built on this foundation. The right to appeal is a fundamental pillar of justice. Yet, this House is being urged to treat a suspended, appealed, and contested High Court and repudiate our legacy of institutional restraint. Let us be unequivocally clear. By acting now, we are not following precedent. We are shattering it. We are declaring that for the people of Kpandai and for Honorable Matthew Nyindam, the historical respect for the process and appellate right is null and void. We are telling the 363,734 citizens whose clear will is not in mathematical that their vote is expendable. We are telling Honorable Nyindam that his constitutional right to appeal in the Court of Appeal, its pending task, is irrelevant. This is not upholding the law. It is a selective, cynical, and historical illiterate application of it. If we proceed, we do not wrong Kpandai today. We establish a toxic new order to instantly unseat a political opponent, rendering the appellate courts and our own historical practice. We must, one, acknowledge that a stayed and appealed judgment cannot be others confirmed. Number two, we defer any action until the appellate process is conclusively complete, respecting the precedent set across decades. And number three, we need to recognize that this premature notification violates the separation of powers, disrespect to the judiciary, unjustly disenfranchises the people of Kpandai, and betrays Parliament's own tradition of constitutional caution. And finally, number four, need to withdraw the notice of the Electoral Commission to the Electoral Commission immediately. This is not a partisan plea. It is a call for basic constitutional fidelity and historical consistency. In conclusion, I stand here for the rule of law and for the sanctity of our parliamentary the separation of powers. It is a usurpation of appellate jurisdiction, a disenfranchisement of Kpandai voters, a denial of Honorable Matthew Yindam's rights, and a gross departure from our own settled practices. Accordingly, I submit that this House is constitutionally, legally, democratically, and procedurally bound to withdraw the premature notice issued to the Electoral Commission. Let history record that this Parliament chose the wisdom of its past precedents of Nyamakan, Abu Dhabi, and Muatin over the rashness of partisan expediency. Respect the stay, await the appeals, honor our history, uphold the Constitution. The people of Kpandai are watching. Ghana is watching. History is watching. Thank you very much.